Hi Swifties, welcome back to my channel. I'm the Taylor Swiftologist, and today we are going to be discussing the Shake It Off lawsuit. If you're new to my channel, I am a journalist by trade and Swiftie by choice, and on this channel I make weekly thoughtful videos about different pop culture related topics. I'm currently talking a lot about Taylor Swift, but I will be branching out very soon. So if any of that sounds interesting to you, subscribe, like this video, leave me a comment with video ideas. I am always pulling stuff from your guys' excellent little brains. So I wanted to discuss this topic on my channel, first of all, because some of you have been asking for it, and you know I live to please. But this is an interesting case because it is, I think, the first of its kind for Taylor, and it is an issue. Copyright songwriting lawsuits is an issue that has been plaguing the music industry and big pop artists like Taylor Swift, Ed Sheeran, Robin Thicke and Pharrell, Katy Perry. I mean, the list goes on and on. And I think that there are a couple of unique particularities about this case that raise something interesting about popular music, what we know about it, how we hear about it, whether something is original or not. As a journalist, I wanted to look at some of the evidence that was presented, read the facts, and make an evaluation or a judgment based on my own personal opinion. Now, disclaimer, I am not a lawyer. I am not a legal person at all. I have some familiarity with reviewing legal documents just in my line of work, but I am not by any means trained to have an understanding, a deep understanding of these issues, particularly as they pertain to the United States, which, as I will go on to discuss, is an extremely litigious society. So before I get into kind of the meta larger commentary on it, I thought we could break down exactly what's happening, how long it's been going on for, and how Taylor has kind of navigated it so far, because it seems as though many people know bits and pieces about the case but not the full story, and I think it is a little bit more simple than it seems. Since 2018, Taylor's been in active litigation with the co-writers of a song called Players Gon' Play, which is by the girl group 3LW, notably including two members of what we now know to be the Cheetah Girls, who are not involved in this suit, by the way, because they didn't write the songs. The co-writers of the song claim that Taylor plagiarized the refrain, "Players gon' play, haters gon' hate." Taylor recently filed her rebuttal statement, which is hilarious, and also kind of her first formal address from her words on the matter, so we'll get into that later on in the video. But a little bit of context for the uninitiated. 3LW was a middling R&B girl group founded in 1996 that kind of formally disbanded for the first time in 2001. Their direct competitors at the time were bands like Destiny's Child and TLC, these massive sellers with huge worldwide commercial success. But 3LW struggled to carve out a unique sonic identity, and they really only achieved a very moderate level of success. I think it's important to note their relative obscurity, because whether or not Taylor had encountered this song before becomes very important later on in the litigation against Shake It Off. So one of their modest successes was a song called Players Gon' Play, which contains the lyrics in question. It peaked at number 81 on the Hot 100, and subsequently, after the song was released as the final single from their second album, they were disbanded and shelved by their label. The songs weren't hitting and the group wasn't selling enough. So in short, their cultural penetration, as in their ability to reach the masses as a pop act, was not very good. The writers of this song, Sean Hall and Nathan Butler, are not cultural penetrators in their own right either. And I think it's fair to judge a pop songwriter's success by the endurance of their output, because after all, that's the job description. They're supposed to be writing hits. So some criteria that I asked myself when I was looking up these songwriters and their history is, do we know their songs today? Can we sense their fingertips on a track before we know it's them? The answer is no. For prolific songwriters like Max Martin, Jack Antonoff, Dr. Luke, Taylor Parks, Julia Michaels, Justin Tranter, and Victoria Monet, to name a few of the current hit makers in our society, we can see they've consistently produced big hits for huge artists time and time again. And some of them even have a kind of little fingerprint that they leave over the work. For example, Jack Antonoff's work is often described to have a certain quality that emerges through any artist that he works with. Whether you like that or not is up for debate, but it's true that he has a very defined sonic identity and a long track record of making songs that are critically successful, but also, more importantly, commercially successful. So Sean Hall and Nathan Butler, the co-writers of Players Gon' Play, have never had a massive hit. If you look through their discography, it's kind of a head scratcher. Their current works are not even really in the commercial radio field, and their kind of last known popular works were in around 2009, 2008. So while they have worked with some bigger names like the Sugar Babes, Backstreet Boys, and Pink, their songs tend to be non-single album tracks, also called filler, buried beneath the really good songs that carried the album and its promotional campaign with a big single or a major success. I point out their relative obscurity to kind of underscore that I think there's a motive behind this lawsuit that goes beyond just upholding artistic integrity. These men have been out of work. They need some coins. And who has a lot of coins? Taylor Swift has a lot of coins. The suit was originally dismissed by a judge in 2018 who described the lyrics as too banal to be copyrighted, and in his decision he cited 13 other songs by huge and popular writers and artists that contained variations of this phrase. The co-writers of Play Is Gone Play obviously appealed this decision and sought a jury trial and damages, and a federal court agreed with their appeal and reversed the decision to dismiss the case in October of 2019. When the decision was reversed, Taylor's representation said, "These men are not the originators or creators of the common phrases, players or haters or combinations of them. They did not invent these common phrases, nor are they the first to use them in a song." They also expressed their confidence that the true writers of Shake It Off, Taylor Swift and her co-producers Max Martin and Johann Shellback, will prevail again. Hall and Butler's claim is not a crusade for all creatives, it is a crusade for Mr. Hall's bank account. So 2 months later, Taylor requested a summary judgment that would have immediately ruled that she did not breach the copyright and effectively throw the case out of court. The judge refused, and when he refused, he said, "Though there are some noticeable differences between the works, there are also significant similarities in word usage and sequence structure, that the court cannot presently determine that no reasonable juror could find substantial similarity of a lyrical phrasing, word arrangement, or poetic structure between the two works." I can kind of see what he's saying here. He's agreeing with the original decision that the phrases themselves, players gonna play, haters gonna hate, are too banal to have copyright over themselves, but I think the issue that he is kind of picking up on here and could be a problem down the road is the sequence. So having one follow the other, players are gonna play, haters gonna hate, in conjunction, the two of them together, that might be the point of contention and where a copyright law might come in, because players gonna play, haters gonna hate are two separate things that are known in the public domain, whereas the combination of the two could maybe be argued to have been an original thing created by the writers of Play Is Gone Play. So that's the problem I think we're gonna arrive at when the trial goes to a jury, if it does. This is also not Shake It Off's first lawsuit. There was another party that tried to sue her for $42 million, but the case was dismissed due to a lack of evidence. Most recently, Taylor's team has filed yet another motion to dismiss this, arguing that there is mounting evidence that Taylor had never heard the song in question before she wrote Shake It Off, which would make the copyright suit a moot point entirely, because if they can prove that she hadn't heard it, then there's absolutely no way she could have copied it. A jury trial would maybe not be good for Taylor, as they are kind of hard to predict. Human beings are fickle and can be swayed by different kinds of emotional arguments, and I think this is why her team is fighting really hard to try and stop the litigation here before it goes to trial. Theoretically, the easiest thing for her to do would be to ask the other party to name a number and settle. Maybe she's done that already and she didn't like the number and she didn't want to settle, but I can actually see her as her character as a person. She would not want to settle for something that she doesn't believe she did wrong doing. She has enough money to make it go away, but knowing her, I think that she's much more morality than profit driven, though she is very money hungry at times. And settling is, in a certain way, an admission of guilt. She's done nothing wrong, so why should she settle? I'm kind of with her on this because I genuinely don't think Shake It Off is plagiarized, but we'll get into that more later. So if she loses, say the jury goes rogue or, whatever, something else happens, then she could have to forfeit future royalties from Shake It Off, her biggest hit, and she may also have to pay damages, and that can get costly when lawyers' costs, etc. are added into consideration. Again, money is not a problem for her, but the public humiliation of a judgment like that, I think, would be very damaging to her career and also would set a bad precedent for other artists. This exact scenario actually happened to Robin Thicke and Pharrell versus the Marvin Gaye estate over the song Blurred Lines. I think they ended up paying them $5 million upfront and 50% of the royalties in perpetuity, so forever. Taylor's argument against this being plagiarized centers on the two phrases, players gonna play, haters gonna hate, being in the public domain. So when a phrase or an artwork is not protected by copyright law or intellectual property laws, it is considered to be in the public domain and anyone can use it without getting permission first, but no one can ever own that phrase. If she can argue that these phrases are in the public domain, then the co-writers don't have a leg to stand on. But the judge has pointed out something that may have some serious implications for the trial and kind of opened up a window where a copyright claim could be asserted, and that was in him saying that the sequencing of the two common phrases placed together may not have been in the public domain before Play Is Gone Play came out as a song, before Shake It Off came out as a song. Taylor recently filed a sworn motion to dismiss the case, and in it she states that she was a sheltered child who lived on a farm and was not allowed to access TRL. She only listened to country radio and she didn't visit her friend's house because her mom would have let her go on sleepovers, so she couldn't have possibly heard it there. Her mom also filed a statement to basically say the same thing, that she kept Taylor at home and strictly monitored her internet and radio access. Now, I guess I can offer my opinions and thoughts on this matter. And first of all, I think it's highly likely that Taylor had not heard the song Play Is Gone Play before she had written Shake It Off. The first point of evidence that I would like to call to the stand on this matter is her track record as an original songwriter and the many people who can attest and have attested to her process. There are plenty of co-writers, producers, editors that would hop on the mic and say very readily exactly what they witnessed, which is that Taylor comes up with these ideas themselves, executes them, sometimes needs some help polishing them, or cares to do a collaboration. She's very capable, willing, and ready to do these things on her own. Because these issues of writing, credit and originality are becoming more and more prevalent, Taylor documents her writing process. I know that we all think she does that as like a cute thing for her behind the scenes of writing a song process or for making voice notes as addendums to an album, but I actually think that there is a more practical purpose for these, and it's to prove with, timed metadata on the video that she came up with something in that given moment. There were other people in the room that could attest to it, etc., etc. I wouldn't be surprised if this does in fact go to trial. There might be some evidence of her recording Shake It Off and her coming up with the lyrics by herself presented. We've seen some of the videos of her recording Shake It Off already, and I'm sure there's very much more of where that came from. Ed Sheeran has actually been embroiled in similar battles to this one with Taylor over many songs, namely Photograph and Shape of You. I think he is a more derivative artist than Taylor, meaning that he doesn't really care artistically about the process, and he's not married to any sort of like creative integrity per se. I'm not trying to put him down. I don't love the music, but I think that he's definitely more formulaic about his approach to writing songs. And I definitely think that when you're not attached to the product, it gives you more room in your brain to let other influences come in so that you can make a quick buck, if that makes sense. The lawsuit that was brought against him for the song Photograph was settled out of court. And as I mentioned, settling can kind of be considered as an admission of guilt at some times. If you listen to the song that Photograph was allegedly ripping off, the two sound much more similar than Play Is Gon' Play and Shake It Off. So he recently, however, had a much bigger lawsuit against the song Shape of You, and he won that. And when he won, he tried to make a couple of points. And his first point was that baseless claims are over litigated in the music industry and that we should all kind of like feel scared and feel sorry for artists. But first of all, it's only artists of a certain magnitude that have to deal with multi-million-dollar lawsuits on this scale. So that's first of all, boohoo. I don't really care if a millionaire loses some millions of dollars. Furthermore, these cases mostly take place in the United States, which is an extremely litigious society, and the justice system is pretty much the only method of accountability that exists. So obviously people are going to use and abuse it. People spend their entire lives either trying to avoid getting sued or trying to sue other people to get some profit from them. I think the better point to make here that I think he hinted at as well is that constituting an original idea in the information age is a very difficult thing to do. The truly original idea is something that maybe we really shouldn't hew to anymore. There are just too many reference points, and there's too much information coming at us at once. We take in information subliminally all the time. Think about it, all the daily interactions where you see an ad, or you look on your phone, or you hear the radio, or you listen to other people talking. For example, yeah, okay, maybe Taylor didn't hear Play Is Gon' Play at a sleepover, but theoretically, what if she heard it on the radio at a Dunkin' Donuts or in a gas station? Those are all kind of plausible things that could have happened to her, just based on the sheer amount of information and things that we see and hear on a daily basis. Theoretically, it's very possible that she did hear it. Do I think that she remembers hearing it or that it inspired Shake It Off to be a plagiarized work? No, I don't think that at all. But what I'm trying to say is that the idea of an original idea as being something that springs up out of a vacuum, out of nowhere, that has absolutely no relation to the context that it exists in or the cultural moment that it comes from is silly and a kind of reductive way to view copyright and intellectual property. But I guess we don't really have a better mechanism to decide what's original and what's not original at this moment, so we're kind of still sticking to this. Another point that's interesting to make that I think kind of helps to strengthen Taylor's point, which is that she had never encountered Play Is Gon' Play and was not likely to based on her listening habits and her demographic and where she came from, is that music is often segregated commercially. The R&B, hip-hop, urban grouping of artists is kind of porous, and there's been much debate about who fits into that group, why they've been put there in the first place. They use it kind of at award shows, the Grammys most notably, to kind of shove Black artists into a niche box and try and argue that by nature of who they are making a certain style of music. Beyonce has been placed in urban categories several times when she should have been placed in the pop music because she is, at the end of the day, a pop artist. So this dates back in America to pre-civil rights when radio was actually segmented and white radio stations wouldn't play songs by Black artists, and they instead preferred to play covers of those songs performed by white artists. This idea of media or music being segregated commercially still exists to some extent. Here are some tweets by one of my favorite content creators, Kimberly Nicole Foster, weighing in on this issue. Another point about originality is that pop music is formulaic. Within this genre, songs, artists, styles don't differentiate hugely. The whole point of pop music is that it's simple and that it's easy to understand, it's palatable by a lot of people, and it's similar to itself. Whether Taylor's doing a rock or an alternative or a country album, she's used pretty much the same formula every single time, which is the verse, chorus, bridge. To surmise, I think any kind of debate about intellectual property rights or, commercial music law is kind of like the Spider-Man pointing meme, especially when it comes to pop music. It's just an endless roundabout of who is original, whose idea this is, when, all roads lead back to each other. We consume and recycle content all the time. Something that was kind of funny to me about this case, obviously it's not funny to me that someone's trying to accuse Taylor of plagiarizing one of her biggest songs, but something that was funny to me is Taylor's response in her sworn motion that she filed, just because she's had to, in a very serious way, lay out the most inane song that she's written in her career. And that's not to say that Shake It Off is bad, it's just an extremely simple and easy to understand song. So hearing Taylor kind of Taylor-splain the song is very very funny to me. Here are a few highlights from the motion that she wrote in her own words to kind of show how silly this is. I recall hearing phrases about players play and haters hate stated together by other children while attending school. These phrases were akin to other commonly used sayings like don't hate the playa, hate the game, take a chill pill, and say it, don't spray it. I just thought that that was such an interesting combination of common phrases to put together. You know, they all say such different things. I drew on these commonly used player and hater phrases in creating the lyrics written out verbatim, because the player's gonna play, comma, play, comma, play, comma, play, comma, play, and the hater's gonna hate, comma, hate, comma, hate, comma, hate, comma, hate, full stop. She also further goes on to break down her lyric writing process. The phrases, heartbreaker's gonna break, 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 and the faker's gonna fake, 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 were included because they also fit the beat of the song. They loosely rhymed with my versions of player and hater phrases discussed above. I love that. Player and hater phrases, Taylor's version. Stream it. They also represented other forms of negativity that a person can shake off through music and dance. In 2013, approximately a year before I wrote the lyrics to Shake It Off, I performed at the Billboard Music Awards wearing a bodysuit that incorporated a t-shirt emblazoned with the phrase, haters gonna hate. A true and correct copy of that t-shirt is attached to this declaration at Exhibit 117. The t-shirt was purchased from a store, Urban Outfitters. Heard of it? I wore that bodysuit for my performance at the Billboard Music Awards because I was struck by messages that people prone to doing something will do it, and the best way to overcome it is to shrug it off and keep living. I am spiraling. I don't understand why this makes me laugh so much, but it's so funny to me to hear her explain Shake It Off in such an involved manner when, like, you can really get the point of the song by either listening to the chorus, which is approximately 20 seconds, or you can just figure it out for yourself. It's self-explanatory, really. What are you gonna do? You're gonna shake it off. It means to like dust off something negative, right? Easy to understand. I will also post the picture of the bodysuit in question. It's just so funny to see this. Literally, it looks like evidence from a crime scene when in reality, it is a heinous bodysuit that she bought from Urban Outfitters that she has to revisit and re-acknowledge that she chose to wear this on national television not too long ago. All right, Swifties, so that's it. I hope you enjoyed it. Maybe you guys like this kind of shorter video style from me. Let me know in the comment section. And also let me know what you think about this case. Do you think Taylor's right? Do you think she's wrong? I mean, I feel like we can all say that she's right, but what do you think about this going forward? Do you think there are any other songs that Taylor could kind of run into some hot water for that you can anticipate her maybe getting in trouble for? It seems to me that the more successful the song, the more likely it is someone's gonna come out and say that they wrote it instead. Make sure to like this video, leave a comment, and subscribe to my channel. My Instagram is everything else is linked down below, all my social media, and I will see you in the next video. Goodbye, Swifties.